When it comes to writing retellings, we know it's incredibly important to get our inspiration from the source material and not from other creators who have used that source material to create their own copyrighted characters and events inside of stories. Meaning, we can create our own versions from the originals, but we can't use anything that's too similar to a Disney version of a character. But how similar is too similar? Today we're going to be talking to law professor and everyone's favorite entertainment and IP lawyer, Tony, as he breaks down what we need to know when it comes to getting too close and potentially getting ourselves in trouble, or making sure that we are not getting ourselves in trouble as we're writing our retellings. Let's jump in.
My name is Tony Lee Costas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, TikTok, and YouTube account called The IP Professor that is dedicated to all things intellectual property.
Tony, one of the things I love to talk about on my YouTube channel is writing retellings. Those are twisted takes on classic tales, everything from fairy tales and princess stories to nursery rhymes, legends, and lore. And I always want to make sure that we are legally protected as we are writing these retellings. So I typically say if it's from the original source material that is out of copyright that you are allowed to use, you're good. But if it's too close to something that is held under copyright by another company like Disney, we want to make sure we stay away from that. So when I speak to people, I say in The Little Mermaid, you can use a Little Mermaid, you can use a sea witch, but you cannot go with Ursula specific things. You cannot put in Flounder and Sebastian. So today I want to talk a little bit about how close is too close, what are we allowed to use, and how do we make sure we protect ourselves when it comes to these retellings. So speak to me a little bit about what we need to know when sourcing material to use inside of our stories. What can and can't we use?
So essentially, I want to start off by, since we're kind of talking about it in the context of Disney, I think we should address the elephant in the room that Disney is a media giant. There is no way around it. I mean, Disney has not just the characters, but ESPN, ABC, Marvel. So their library of materials that they have is voluminous. The theme parks themselves are a huge moneymaker. The number I last checked is that as of 2021, their total revenue exceeded $67 billion. So they are worth an incredible amount of money. And not to mention the IP portfolio within that company is probably tenfold. It's probably beyond priceless. So understanding first and foremost that when you're talking about the Disney IP that's just associated with the animated characters and the movies, you're dealing with an unspoken giant. It's unfathomable how huge their IP portfolio is, from the copyrights, the trademarks, even the patents related to their animations that they've done over the years. So with that in mind, if you're an author and you're exploring the world of retelling, it's really, really, really important to know that your use of a character's retelling does not encroach on Disney territory. So I've talked about it before in a previous video with regard to A.A. Milne and the Winnie the Pooh character, the copyright expiring. You want to talk about Christopher Robin and Winnie the Pooh and Piglet and Tigger, that's fine. As long as it's not touching any aspect of the Disney characters, you would pretty much be okay, because the character rights from the book are in the public domain. That's how we're getting Winnie the Pooh, Blood and Honey, the horror movie that hopefully will not emulate any aspect of the Disney characters. Although the guy wearing the Winnie the Pooh mask kind of looks like a deformed version of Winnie the Pooh in the characters. But either way, if you wanted to provide like a retelling of the iconic rendition of Winnie the Pooh, that could be fair game. The characters like Snow White, Cinderella, Pinocchio. Pinocchio is a great example. How many Pinocchio movies have there been? 50 bazillion, right? We just got 2 this year with the Tom Hanks version and the one by on Netflix. So we've got a bevy of different Pinocchio movies, a bevy of different renditions of the books, probably. But the common narrative is that each one has their own unique storytelling aspect of it. And certainly when we're talking about the films, the way they portray Pinocchio is going to be different among all of them, because the Pinocchio in the Netflix movie is different from the Pinocchio that we see in the live action one. And that's different from the Pinocchio that we saw in Shrek. And that's different from the Pinocchio that we saw with Jonathan Taylor Thomas, hashtag 2000. So, we're digging in the archives. So it's very clear that older media of a specific character provides good ground for an author to tell a unique story. It's just you have to make sure that element-wise and certainly story-wise, it is nowhere near Disney, because you're just asking for a cease and desist at that point.
So I want to talk a little bit about how close is too close. And I really like the example, I tend to use it a lot, of The Little Mermaid. I see a lot of people who are very good about making sure they've got a Little Mermaid and a Sea Witch, and they're very clear that it is specific to them and to their story. But I also see people encroaching on Ursula a little bit. So let's talk about, how close is too close? Can they be creating characters with tentacles in the likeness of the Disney version of Ursula? Can they be using Ursula's name but change the spelling or change how it's pronounced? What is it that allows us to do things, and where is that line to make sure that we are not getting those cease and desists sent to us?
So before we kind of dive into that aspect a little bit, if let's say that you created a character, let's use, for example, the Ursula character, right? And let's say you spelled Ursula Ersula, like something like that, right? And the character kind of mimics a little bit of what we saw from the Little Mermaid movie, and Disney comes after you for a cease and desist. They sue you or they eventually sue you for copyright infringement. Now at that point, the question is, do they have a viable claim for copyright infringement? And in any situation when you're talking about copyright infringement, in order to succeed in a copyright infringement claim, you have to satisfy essentially 4 factors. One, you have to show that there's a valid copyright. So in this case, Disney would have to show that they have a valid copyright to Little Mermaid and all the underlying characters, including their rendition of Ursula. Then there has to be a violation of one of the exclusive rights afforded to copyright owners under Section 106 of the Copyright Act. So in this case, some type of reproduction of the original copyrighted work may be a violation here. Maybe even creating a derivative work out of that original copyright may be a violation as well. But the 2 most important prongs in a copyright infringement claim are, 1, did the infringer have access to the original work? And second, this is probably the most important one, and this is the smoking gun in all copyright infringement claims, is there substantial similarity between the infringement and the original copyrighted work? And the substantial similarity prong has been tested in a bevy of different cases. One of my favorite cases that I go through with my students is Rentmeester versus Nike. A lot of you that are sports fans may be familiar that Michael Jordan has his own sneaker line, Air Jordans, and it's that signature pose of him doing the Grand en Jet that has a nod to ballerina. So the Grand en Jet, it's him extending his arms out, and he has the basketball in his hands. That's been his pose. Air Jordan has adopted that as the logo, but it all started because this photographer named Rentmeester took a photo of Michael Jordan on University of North Carolina's campus with him doing that pose for Time Life magazine. I think it was Life magazine at the time, but either way, for Time Life. They set up a makeshift basketball hoop at the top of the hill at UNC's campus. They tell him, Michael, do the Grand en Jet, pretend you're dunking for the basket and you're doing that. They took the photo, end of story. That was in 1984. A few years later, Michael's in the NBA, and he's potentially getting a lucrative Nike deal. So Nike wants to kind of create marketing around Michael Jordan. So they asked Rentmeester, can we use your photo? Can we have permission to use to view your photo? Not permission to use the photo, just to have access to the photo. So the Rentmeester provided a color photo of Michael Jordan doing the Grand en Jet at UNC's campus. And essentially, Nike replicates that photo. But this time, if you look at the photos side by side, the way Nike did the photo, they have Michael Jordan in an actual basketball court in Chicago with the Chicago skyline in the background. And posturally, even though he's doing the Grand en Jet, there were aspects of his posture that were different from what you would see in the Grand en Jet in the UNC photo. Rentmeester sues for copyright infringement. The long end of it is that the court found that there was no copyright infringement because in cases of substantial similarity, when you're trying to satisfy that prong, it's a matter of finding out, is it basic plagiarism where you're literally copying frame for frame, image for image, pixel by pixel, a copyrighted work? Or is it a situation where, yes, there is some type of similarity, but there are several aspects that are too dissimilar to make it copyright infringement? So in a situation like Little Mermaid, if you're going to make a character called Ursula, Ersula, it's such a mouthful.
Yes.
If you spell Ursula that way, and that's the only element you're changing, and everything else about that Ursula character is the same, consistent with the Disney character, you got a bona fide copyright infringement claim right there, because there is nothing different about those two characters except the spelling of the name. Now, of course, names are never protected under copyright law, but I think the exception is with fictionalized names like Ursula. So that's even an exception there. But let's say that you created a villain that wasn't called Ursula, but maybe they had tentacles, but they weren't they weren't purple and had white hair. Maybe it was like an actual rival mermaid that had a tail, but out of the tail were tentacles. That is a fairly transformative treatment of a villain character in The Little Mermaid that is not going to satisfy that substantial similarity prong, and thus not lead to a copyright infringement claim. So being mindful that you can't do the bare minimum, essentially, is how you're going to evade the copyright infringement question in situations like that. So just changing the name is not going to be enough. You're literally going to have to sit there, and if you've got writer's block, think a little harder, because you're going to have to be super creative to try to transform away from the Disney character and come up with your own character.
So it does have to be transformed enough that you can reasonably argue this is not the same character and it's not copyright infringement, to make sure that you are protected in this. And making sure, if you have questions, that you're checking in with a publishing or entertainment lawyer is going to be the best thing that you can do to make sure that you are legally protected in this. Now, let's say we've unfortunately made some mistakes and we are a little bit too close and we get one of those dreaded cease and desists. How should we as authors then proceed to make sure we're complying and we're handling things so that we do not go into a lawsuit?
First, go to a lawyer immediately. You're going to need to speak to a lawyer and have them review the letter. And then, of course, that's where the next phase of it is. Your lawyer is going to want to know, what was the character in question? How did you describe it? If you had illustrations in the book, what does it look like? All that discovery, if you will, is going to be paramount for a lawyer to understand if there is a strong legal claim from Disney or not. Sometimes you can, these companies, if you provide some type of, plea or are a bit sympathetic or apologetic, they might be more willing than not to let it slide, and just make sure you don't do it again. But you have to be very careful, to not tiptoe that line, or certainly if you don't go to a lawyer and you just handle it on your own, you're going to breed chaos and trouble at that point. So yes. Just really, really important to get that legal help that you need to assess that matter. Maybe sometimes part of the process is you're going to have to cease the distribution of that book. You're going to have to rewrite it and rewrite aspects of it where there is a different character that doesn't derive from whatever Disney is disputing as copyright infringement. So that might be a part of the process. You may have to pay a license fee if you still want to remain, keep that character, but you want to, you don't want to deal with Disney anymore. So there are a number of different ways to resolve the matter. That's a dispute resolution discussion that I think is very personal to each author, personal in each circumstance. But priority number one in any situation like that is asking for a lawyer for their own independent assessment, because they may see a viable legal argument that could warrant you not even having to pay anything out to Disney, or not even having to worry. They could see that maybe what you created is in fact a new copyright that doesn't breach on the copyright that Disney has in their hands. So there are a number of ways of navigating it, but a lawyer will definitely help you understand where you stand on that front.
And you talked a little bit about making sure we're not doing the bare minimum, putting that small amount of effort in. And I feel like I would really love to have a conversation about, let's say we have done something wrong, we get the cease and desist, we are going to then move forward and change the book to make sure it can stay out on the market, but does not infringe on their copyright. Should we change a little bit? Should we change some? Or should we do a major overhaul of this just to make sure we're protected?
I mean, I would say the more you can change, the better. I think people don't understand that, yes, lawsuits, 90% of lawsuits always end in a settlement, but it's that, before, when a case is about to go to court, there's so much work that happens in that, in the months prior, years prior sometimes. There's the purchase of an index number. There's a delivery of the complaint. You have to hire a process server to deliver that complaint. Then you got to answer, and then you have to have motions for motions for dismissal, trial hearings, if you will, discovery, depositions, this and that. It's such a process. Nobody understands that. It's not like what it is in Law and Order, where you arrest the guy and it immediately goes to court. No, it's not like that, even though they showed that the time difference exists. It is a very, very lengthy process that leads up to that trial. Why worry about that? Why have that looming in the back of your head? I think we live in a society where we're all capable of some level of creativity. And, I'll give you the tidbit, this is a hot take from the IP professor here. Our judicial system has set an extremely low threshold for originality in the context of copyright. Literally, I could draw a stick figure and I could put a goatee and a cowboy hat, and in the eyes of our judicial system and case law, that is original under copyright law. So literally, if you want to call your villain, instead of Ursula, tentacle guy, hey, that's pretty creative enough in the eyes of the copyright law. Go with it. Yeah. So certainly there are aspects of manipulating and changing and transforming something new out of, you can draw inspiration from the Ursula character. You could draw inspiration from Ariel. You could draw inspiration from Gaston and LeFou and all these characters from The Little Mermaid. Mm-hmm. But it's about transforming it so that there's no shadow of a doubt that there's a connection between what you created and what Disney has in their back pocket. So, blurring that line and making them as separate and as distinct as possible is really, really, really important. So the more you could change, the better.
I love it. The more you can change, the better, the safer you are going to be. So make sure that you are taking steps to protect yourself and creating original, unique characters inside of your stories. And as always, if you've got questions, go talk to your lawyer. If you also have questions, we're happy to answer those down below. So make sure you hit us up. But if you have case-specific conversations, that is with your own personal lawyer. But if you are interested in learning more about writing retellings, we've got lots of great workshops and videos down below, and lots of episodes with Tony to make sure you are legally protected inside of the publishing industry. And of course, you can hang out with Tony online on his platforms. Tony, where can we find you?
You can find me on Instagram, TikTok, and YouTube at the IP Professor. And if you have any questions on videos that I've talked about or on different subject matter, you're happy to reach out to me on the DMs.
If you have further questions on this, go ahead and drop those down below so we can get them answered for you. And make sure you are checking out our Retellings workshop, which I've linked down in the comments below, to help you level up with what you are writing inside of this industry, inside of your genres and your tropes. If you've got any questions, we would love to get them answered. And be sure to hit that subscribe and notification bell, because there are more episodes from Tony coming, keeping you legally protected inside of the publishing industry. And I'm dropping videos daily to help you level up on your social media marketing, growing in the publishing industry, learning how to write from professional authors who have figured out strategies that might just be the perfect thing for you, and making sure that you are staying safe and productive inside of this industry, while also avoiding a lot of the stress that some authors put on themselves while they're trying to do all these things. We'll see you in the next episode, but if you've got questions or if you want to see episodes, let us know down below.